Good morning and welcome to the Kenny and Sam's Construction Risk Management Series. This is, I believe, our 8th program. I'm Mike Sams and this is my partner, Drew Colby.
Good morning.
We really appreciate you joining us for today's discussion on no damages for delay clauses and making claims and the risks related to both of those things. Brief intro, Kenny and Sam's is a civil litigation, trial practice, and risk management firm. We handle all types of civil disputes across the spectrum, from employment to shareholder disputes to business. But we're not here to talk to you about all of those things today. We're here to talk to you about construction risk management, very significant part of our practice. It's most of the work that I do. It's most of the work that my partner Drew here does. Drew, do you want to introduce yourself a little bit?
Sure. My name is Drew Colby. I've been practicing construction law for over 35 years. Hard to believe, but that's the case. I predominantly, my practice is split in half. I draft and review construction contracts, and I also deal with payment and performance issues.
So the fact that we do a lot of trial work here also helps us understand the risks and the flaws that are inherent in some contracts. And that aids us in the risk management work we do when we're allowed to upfront work with you on the risk management and drafting and negotiating contracts and trying to help you when blips come up on jobs. Nobody's fault, but these things happen from time to time, and it's important that we help you with those sorts of risks before things get out of control. So along those lines, we're going to be talking about claims, risk management, and no damages for delay clause today. Let me kick it over to Drew.
Yep. So just to echo on Mike's point a little bit, every time I have a litigation or arbitration that involves a contract provision, I make a note of that. I have a form that I keep that say, this is the dispute, this is what happened, this is how they got there. And then I draft around it. So when I draft contracts in the future, if I haven't already addressed that point, I have in place a ready-made solution for a problem to prevent it from coming up. So as Mike said, this is our 8th, I think, installment of the construction risk series. We've done them on liquidated damages, cost escalation, hot button employment issues, including vaccination, which is obviously a big one. We've done prompt pay, mechanics, lien laws, et cetera, et cetera. But as Mike said, today we're talking about claims.
And those are all available on our website.
Absolutely,
right?
Yeah. So just if you don't attend them live, it's not like they're lost forever. We put them right on our website. You can find them there. You can also go on YouTube and find them there. But they're a great resource when you get into a situation. You might think you're getting into a situation, just to pop online, take a look at them and see what's in there that we put. We don't lecture about things that we don't know about. In this room, collectively, Mike and I have well over 60 years of construction experience. And what we're talking about is things that come from the school of hard knock. These are the things that we've learned over the course of our careers, in which we now hope to bestow upon you and give you the information you need to avoid some of the risks and adverse situations that have happened in the past.
Well said, Drew. Enough of our blah, blah. Let's jump into it.
Let's get right into it. So first, what is a claim? What is this thing? What is a claim? In its simplest terms, a claim is a change to the scope of work in a particular project. It could be they add another floor to a building. It could be they change the location of the bathroom. It could be anything, but it's a change to the scope of the work. Now, one of the traps that people get into in this is it's called different things. Like they might be called a change order when it's really not technically a change order. It might be a proposed change order or a disputed change order. Some people call it extra work orders. Some people call it disputed CCDs or construction change directives. The purpose of this discussion is just to say, kind of ignore what the name is or what the nomenclature is that they use to identify this thing, and understand, does this impact the scope of work? Is this different than the scope of work? If it is, consider it a claim and look at the claim process.
Right, because every contract can have a different claims process, including what's defined as a claim.
Absolutely. And this is where, so what we did when we put together this meeting is to kind of say, where do we find the worst traps for these claims? How do people get in trouble with these claims? And we broke it down into a couple of situations, and we're going to go through them. The first is notice, right? You'll see in these contracts, in the event of a claim or a disputed claim or a change or extra work or blah, 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 whatever they call it, you have to give us notice of this situation. So notice is crucial, and you need to read the notice provision. It might be an easy one for a contractor or subcontractor to comply with, which means 21 days after your discovery of this, Or it might be one that's very short and very problematic, which is you must notify us of a claim before it's disturbed. So you need to look at when the gatekeeper is, when this time limitation is for presenting a claim, because that is probably one of the first and most prominent defenses that's asserted against an otherwise valid claim. So the goal of a notice is to bring as many brains into the problem and to the solution as they can at an early time, so they can manage this situation.
Can I just jump in for
Yeah,
just one second? A practice pointer along those lines. Because the notice provisions in the notice provisions in your contracts at times can be really short. Really short. Sometimes I've seen them for 24 hours. You have to put somebody on notice of a claim within 24 hours or your claim is waived. Maybe it's 48 or 72 hours. But in any event, all three of those examples are really short period of time. As Drew's going to review, there's a risk and there's an argument that if you don't comply, you've waived your claim. That is, can you imagine you got a $100,000 change order claim and you don't make it on time under the contract, therefore the other side's arguing you waived your claim. So what's my practice pointer tip along these lines is on all of your contracts, before you get into them, make sure whoever is responsible for managing your job and ultimately for submitting claims, that person or people are aware of exactly what the claims order, what the claims process is in your contract and what the deadlines are. Sorry, Drew.
yeah, no, that's absolutely appropriate and great advice. So what's the purpose of notice? The purpose of notice again is to bring as many people into the process as possible before the work is done. For example, if a contractor doesn't own boulder removal or ledge removal, and they come across a boulder or ledge, you don't want the contractor blasting through the ledge, submitting a large claim, when the more appropriate solution would have been to go around it. Right? So that's the whole purpose. The purpose is to get the owner involved, the architect involved, whoever needs to be involved to kind of find and manage this situation that arose on a project. And that's why the notice provisions are important, because someone will scream, the owner will scream, I didn't get notice of this. I would have just gone around the thing and done it at half the cost and half the time. So that's kind of where the defenses come up on the notice side. So pay real strict attention to notice. The other thing that you have to pay attention to, in addition to notice, is content, right? Content and delivery requirements. The contract will usually say what the content of the notice is, right? A lot of times you have to justify, the contractor or subcontractor will have to justify the change in time or cost. And so you need backup documents, you need this. So you have to make sure that you understand what the contract requires in terms of what the content of that notice is, because that's often used as the defense. If there isn't any content parameters set forth in the contract, then describe this thing as carefully as you can. Focus on the contract. Say, start with a contractual entitlement and say, we excluded ledge from our work. This is ledge, therefore it is an extra. Then jump into the cost and articulate the cost. The clearer you are with a description of what the change is and why there's an entitlement to an adjustment in the contract time or sum or both, the more likely you are to prevail on that sort of a claim.
And I've had clients say in the past, well, I didn't submit the claim within the 72 hours because, yeah, I knew that there was a potential claim, but I didn't really have all of the backup documentation or all of the details that I needed to be submitted based on what the contract says I needed to provide to satisfy the notice provision. The answer is meet the deadline. And if you don't have all of the information, then indicate, this is what the claim is about. This is about a ledge claim. We anticipate there's going to be a significant cost impact and a time impact. We are pulling that information together and will seasonably supplement this notice. That is, get your notice out within the deadline period. Don't wait and blow the deadline thinking, I need to have all of the info. Indicate what you've got at the time and then timely follow up with the additional information as you get it.
Yeah, and another point that follows along that line is be mindful of what we're going to get into the monetized part of the claim in a few minutes, but one thing that I negotiated a contract this week, and I saw a claim provision in there that says, provided you do the notice and everything else correctly, we're going to give you a claim, but the claim is limited to the estimate that you put into your original, extra work order or change or proposed change order. And I looked at that and I said, well, they're asking us to monetize a claim before the work has actually been performed. And I see two risks to that. One, that it might cost more, and secondly, they might delay the time frame for us to perform that work. So what I do is I reached out to the client and said, when do you have to pre-order materials to do this? They said, we can get this thing done in a couple of days. We can fully encapsulate and capture our costs for this, but we can only hold those costs for a certain period of time. So I went back and I negotiated the contract to say, okay, we'll accept the estimate as our bottom line on this thing, provided we're permitted to begin that work and finish that work within a 2-week period of time. So what I'm trying to avoid on the client's part is getting stuck with a cost escalation. So when you look at these claims, you also have to look at how they're being monetized. But we'll touch on that a little bit more later on. Also, you have to look at the delivery requirements. Often these contracts will say, you have to give us notice of a claim by certified mail, by courier, or by hand delivery. Email's beginning to creep into these, and when I'm representing a sub or a contractor, against somebody that's higher up in the hierarchy, what I always say is with an advanced copy via email. The whole purpose of the notice requirement is to give people an advance notice of a situation. So if you send it by email, they can't then later on claim, we didn't know about it. We typically would send those emails, with a delivery receipt and a red receipt. No one ever checks off the red receipt, but at least you'll get a delivery receipt so you know that they received notice of that claim on a timely basis and that it went to the right people. The next part of this deals with to whom it must be sent, right? This is a technical defense that's advanced often by people that want to deprive you of your valid claim, right? You didn't send it to the right people. If you sent it to the right people, who knows what would have happened? You didn't send it to the right people. Take a look at the contract. Identify specifically to whom notice must be sent. It's usually articulated in the contracts. The standard AIA contracts always has a section in there, to whom notice must be sent. If your contract doesn't have the to whom it must be sent, send it to as many people as you can that are going to be impacted on this. But typically, the person in the field, the PM, the super, but also the higher ups, so that no one can say, we didn't get notice of this thing. We didn't get notice of this thing. I mean, you basically want to blanket as many people as you can with notice of this particular claim, so you don't get a notice defense back based on the fact that you didn't deliver it in the right hands of somebody. The biggest piece that we see and the biggest risk to contractors is the consequence of not complying with one of these prerequisites for a notice claim. For example, you didn't send it timely. You didn't send it to the right people. You didn't have enough content in there. You didn't send it by the right delivery method, right? What is the consequence? And this is a big deal. What is the consequence of not presenting a claim in a valid manner, right? If you read your contracts, most of them will say that the consequence of failing to comply with one of these prerequisites for asserting a claim, the process of the claim, is a waiver. You'll see claims that say, regardless of the validity of this claim, if you don't comply with one of these notice requirements, you've waived this claim, right? That's a catastrophic outcome that is achieved by the failure to meet a procedural and sometimes an overly technical standard. And that's what you need to avoid, is this sort of waiver. And I'll tell you how this can kind of sneak into things. Like, I negotiated a contract, I think it was last week, where they said, you have to give us notice of a claim, within 24 hours of your reasonably being aware of it, and you have to give it to us so that we can process it up into the owner. We can bundle it and send it off to the owner. And then it goes on to say, unless the requirements in the owner to general contractor require a shorter period of time, right? So I'm looking at this and saying, we have no idea what those notice requirements are between the owner and the contractor. So what I did was I wrote back and I said, if you let us know what those owner requirements are, then we at least know what we're dealing with. But I can't have this thing that says we have to give you notice with a certain period of time, but there might be a shorter period of time out there. And if you don't achieve that shorter period of time, there goes your claim. We can't have that. The purpose of reviewing a contract is to identify risks and rewards and balance them and make the contracts work for people. When I see a clause like that, it makes me very concerned that we're inheriting a situation, a hazard, a problem that could be fatal to something that's extraordinarily important to our clients. So I reached back out and said, let us know what that provision is. If it's the same as ours, let's just marry these things up and put language in there that reflects it. But I can't leave this nebulous unless it's a shorter period of time out there, unless I know what that risk is. So, this whole consequence of failing to comply with the notice, I know, Mike, you've seen this many, many times. If you don't do everything right, you waive it. The way I try to massage those, particularly when I'm in the lower end of the hierarchy on these things, is to qualify them to some extent. For example, I might put in there that we waive them, but only if the person to whom we were supposed to give notice or in some way didn't comply with this thing experienced a material prejudice as a result of our failure to comply with this. And I might also qualify by saying, these don't apply if they had knowledge independently. I negotiated a contract a couple weeks ago that said, if you don't comply with all these notice provisions, you waive your claim regardless of the validity, even if we knew about it independently. And I'm saying, well, the whole purpose of the notice is to prevent prejudice to somebody. It's to bring people together to find a common sense solution, the most cost effective, time sensitive solution to a problem. And you already know about it. You've worked with us to find it, but we didn't technically comply with a notice requirement, and therefore that claim goes out the window. Um, that's exactly the type of stuff that's breathed into these contracts that presents an unreasonable risk to people. And of course, I had to get rid of that. So when I look at these, what's the consequence of failure to give notice? And I see this, it's an automatic waiver. I do try to, particularly if I'm representing somebody in the lower end of the hierarchy, um, mitigate the harsh consequence of that by including a material prejudice, by including, this doesn't apply if you already know, and other language along those lines. We had to do it in any event. If we didn't do it right away, we would have blown up the schedule, which would have created more catastrophic losses for you. I try to massage those in a way that manages that risk appropriately, that punishes, conduct that shouldn't have been done, but also doesn't unfairly punish conduct.
Do you want to talk a little bit about how to push back if, let's say we've got a client or, contractors out there, you've entered into a contract that has some bad notice provisions and maybe somebody wasn't exactly aware of what the notice provisions were, and you've submitted a claim that's not in compliance, and the tier above you, whether it's the owner or the GC, is now saying, sorry, you waived your claim. You want to talk about a little bit how to push back on some of that?
Yeah, yeah. So in the war of emails, I find is incredibly ineffective, right? If calling people names, we'll never accept that. That's terrible. I can't believe you have such a breach of trust. This should be a partnership, and it's not. It's a dictatorial process. Emails typically don't work. What I do is I typically jump on the phone, get a conference call with the other side, and say, these are the risks. If you really want to use us, if you really want to use if you need this contractor or you need this subcontractor, you have to understand that we need to manage these risks in a way that works for you and works for us. Let's bridge the gap. And when you have somebody that's reasonable on the other side, it's almost always been the experience that we can bridge the gap and get something that works for both sides.
There are some legal arguments to be made too. That is, Drew started when he was talking about this. The risk is you waive your claim if you don't follow the claims process. That risk comes out of some older cases that were cases involving contractors and awarding authorities, so public entities, where the courts, I think, are predisposed to protect the public entities. And the courts have had some harsh results for contractors in those instances that didn't follow the notice process, the claims process. That is, the court said, you have a contracted claims process, you didn't follow it, you waived your claim. Really awful result. But fear not, as there are some arguments to be made to push back. That is, you can argue, all right, so maybe we didn't dot every I and cross every T with respect to the notice we provided. We didn't send it to this person, but we sent it to these 8 other people, and the company had notice. So maybe we didn't technically comply, but we achieved the purpose. Another argument to be made is that, all right, we didn't comply, but you know what? We didn't comply 8 other times before this claim was made, and you didn't tell us we had forfeited our claim. In those instances, there's case law out there that suggests or says if a contractor doesn't enforce the claims process, it essentially waives, it is stopped from enforcing that notice provision later. The theory being if you've already allowed us to go outside of the claims process, to be not in compliance with the claims process in the way we've submitted our claims multiple times, then it is reasonable that we've relied upon that lack of enforcement of the claims process, and you can't thereafter enforce it. You can't, when we get to the end of the job and we submit this last claim, you can't come to us and say, aha, you're out. You didn't follow the claims process. Because to that, we would say, well, I get it. We're not right in line with exactly what the contract says. We're late in submitting the claim, but we were late on this change order, this change order, this change order, and this change order, and we still got paid. And we relied upon that in thinking that the notice provision was not enforceable. If you can put together such an argument, you can defeat the waiver argument that the tier above you may impose. The problem with that, of course, is it's not a slam dunk. It requires a ton of lawyer time, which is going to translate into costs that come off of your bottom line in the form of attorney's fees. And you're probably still going to be, negotiating to get to a resolution. So my point is there are ways to fight in the event that you fall into the trap of not following the notice provision. But best practices, know what the notice provision is, comply with the notice provision so you don't get yourself in a risky situation with respect to a claim.
Yep, that is the waiver of a waiver defense, and it has been applied, and it does work. Let me tell you one of the traps that you might not know about that can hit you right square between the eyes, and that's the lien waiver, right? A preliminary, partial lien waiver, et cetera, et cetera, et cetera. Here's the cost of the contract, here's the approved change orders, here's what you've been paid. You've been paid everything else up to date. If you're a subcontractor or a general contractor and you see one of those on a preliminary, not a final lien waiver or release, but on a preliminary one, I always insert a line that says, except for disputed sums and retainage, right? So that you're not waiving your right to a change order. If there's a disputed change order, disputed claim, extra work order, whatever you want to call it, but it's not a line item in a lien waiver, there's an argument to be made that by not including that in the lien waiver, that you've waived that claim. And if you read these lien waivers, it does say you've been paid everything up to date. You acknowledge by signing this that you aren't owed any of the money. So watch out for the lien waivers because they can be a backdoor way to wipe out even a valid disputed claim or an extra work order. Finally, let me give you a practice tip. This is contrary to lawyers. It hurts us, but it helps you, and it's a really good tip to know. Monetize your claims in advance, so that when you're fighting about a claim, you're only fighting about entitlement. Do I get it or don't I? So what I do with my contracts, I say, in the event of a dispute over a sum of money, this is how we're going to do it. You're going to get your actual cost, subcontractor cost, a markup, some percentage for insurance, et cetera, so that the parties know that if they get into a dispute about a claim, the amount is already established. All they're fighting about is entitlement.
That is how to formulate the claim, and sort of the arithmetic formula for the claim is already built into the contract.
Right, because if you have a extra work for $30,000 and you have to prove the cost of that, the proof of the cost of proving it might exceed the cost of the work, and you're at a loss already. So monetize, put a formula in place that says in the event of a claim, this is how we're going to determine the value of it, so that you're only fighting about is it an actual claim or isn't it an actual claim. The last thing I'm going to talk about is limitation of claims. I already talked about, that you might get stuck with the estimate of your request for a claim, but there's another one too. And I negotiated a contract, I think it was this week, that had a paid if paid clause in it, right? So in other words, regardless of validity of your claim, you did everything right. Notice, content, delivery, to whom, all that stuff's great. Hunky-dory, perfect. You only get what I get from the owner, right? That's the dreaded paid if paid clause, right? That's a backdoor way to limit the amount of a valid claim. Keep an eye on that. We usually strike them, or we'll put in language that seems like we're giving something to them that they're not. Say, okay, but we'll agree to a pay to paid, but only if you're not paid as a result of the work that arises from this particular claim. and in which case you can withhold it. So it looks like we're giving them a pay to pay, but we're really not, because the contract allows them to withhold payments from you if the owner won't pay because of your defective work in the first place. But watch the pay to pay. The other one is the no damage for delay, right? And Mike's going to talk about the no damage for delay. That's a big, big one that could defeat a valid claim.
Thanks, Drew. So let's start with the proposition that no damages for delay clauses are enforceable. They seem unfair. The other side delays you on the job, maybe two tiers up delays you on the job, but there is a no damages for delay clause in the contract. They are enforceable. There's an exception on public jobs that I'll talk about in 2 seconds, but just understand that if you have a no damages for delay clause in your contract, it is going to be potentially enforceable. Here's what I mean by a no damages for delay clause. The contractor shall have no claim for money damages or additional compensation for delay, no matter how caused, and in such instances of delay not caused by contractor shall be entitled only to an extension of time for performance. So the other side delays you, all you get is an extension of time. You don't get your additional costs. As I said, there's an exception, one exception on public. That is, you've got a no damages for delay clause on a lot of public jobs. There is a statutory exception, Chapter 39, Section 39O, that says, notwithstanding a no damages for delay clause, if the awarding authority issues a written delay suspension for 15 days or more, you do get your additional costs related to that delay. So that's one small exception. But otherwise, start with the proposition: if you see it in your contract and you don't want it in your contract, before you sign that contract, take it out. Don't assume that you're going to be able to just defeat it based on some fairness principle, because that's not necessarily going to work. Courts have found that they are enforceable. In fact, they found that they're enforceable not only for delay, but for hindrances. That is one of the ways lawyers cleverly have tried in the past to get around a no damages for delay clause, is to argue, well, it's not really a delay, it's more of just a hindrance. And the court said in the Reynolds Brothers case back in, I think it was 1992, the SJC said, no, you don't get, the contract has a no damages for delay. Whether you're calling it a delay or you're calling it a hindrance, you're not going to be able to recover costs related to that. You get additional time. So let's talk real quickly about ways around or defenses to a no damages for a delay clause. In an older case, the Farina case, what the court recognized was, if you have a no damages for delay clause, but the tier above you is essentially abusing it. In that case, where the court found was the tier above the party subjected to the no damages delay clause, was the tier above was abusing it by what the court called whipsawing the lower tier contractor around the job without any concern for that contractor's time or costs. The tier above was saying, well, you're going to be over here today, you're going to be over here. They were changing the schedule, they were interrupting the schedule at their own whim. And essentially what the court found was, I think, the basis of the court's finding was that the tier above was breaching the covenant of good faith and fair dealing. The court doesn't exactly say that in the case, but it points to sort of that sort of conduct. There's an implied covenant of good faith and fair dealing in every contract. And I think what the court found in the Farina case was that the higher tier was abusing that implied covenant of good faith and fair dealing by whipsawing the contractor around, and therefore could not enforce the no damages for delay clause. In a much more recent case, although now aging, Central Ceilings, there was a no damages for delay clause. Central Ceilings argued that the general contractor could not enforce the no damages for delay clause because the general contractor not only had prevented the Central Ceilings from recovering its delay costs, but hadn't even given Central Ceilings additional time related to delay. And the contract said that if Central Ceilings was delayed on the job, it would be due additional time, not additional costs, but it would be due additional time. And Central Ceilings said, all right, but they can't enforce the no damages for delay clause because they didn't even give us additional time. They breached their obligations to us under the contract. And the court said, you're right, Central Ceilings. The general contractor in that case materially breached the contract by not giving you additional time, and because it materially breached the contract itself, it can't enforce the no damages for delay clause. So a defense to the no damages for delay clause is not only, as in the Farina case where the tier above was in essence acting in bad faith, if the general contractor, the tier above, is otherwise in material breach of the contract, then the argument is you're in breach, you therefore can't enforce your rights under the contract, and we're entitled to get our delay damages. That worked in the central ceilings case. So those are two arguments. Another argument against the no damages for delay clause is, in fact, we weren't really delayed. We lost productivity. Drew, you want to talk a little about that?
Yeah, that's more of an impact case. So when you have a no damage to delay clause, see what it encompasses and look for the word impact. All right, a no damage to delay means that the project was delayed and therefore we have extended general conditions, et cetera, et cetera. We're entitled to damages for that. An impact case says we met the schedule, but because owner, architect, contractor, whoever it is above you, screwed up the schedule so bad, we had to work overtime, weekend, holidays, et cetera, et cetera. So there's an impact on our cost to get the work done, but we got it done on time. That's an impact case. So if your no damage for delay clause says it encompasses impact damages, it might very well even preclude those. So you got to kind of look at those provisions and see, is it limited to delay? Is it limited to impact? And usually there'll be a whole laundry list of terms that they put in there to be as comprehensive as possible.
But if it doesn't include impact and your claim really is, we weren't delayed, but we were impacted, we lost productivity, then it's really important that if your contract has a no damages for delay clause, when you're making your claim, don't cast it as one for delay. You need to lay it out that it's really an impact claim. You lost productivity.
Yeah.
I see that we're beyond the time.
Yeah. Do not confuse those distinctions. It's very, very important. We had a federal case where the client actually mistakenly referred to it as a delay claim, and the awarding authority looked at it and said, well, there's a no damage to delay claim, but it was really an impact case. So we're going to wrap up. The next installment of the construction risk series is going to be on contingency clauses and GMP. Well, it's actually GMP contracts, including contingency clauses. That'll be on the third Thursday of February. And again,
February 17th.
February 17th. And again, go to the website. You can see all of these that have been done. They're all there, and you can watch them at your leisure.
And if you have any questions in the meantime, obviously feel free to reach out to us.
Yeah,
Thanks for your time.
Much.